Today we're going to talk about a few different things. First, there was a recent settlement in a law regarding delayed processing of employment authorization documents. Right now, this applies only to those seeking to renew employment authorization who are either in H4 or L2 status, but it is progress and hopefully overall may reduce processing times for all EADs. First, as to H4 applicants, those of you filing standalone extensions of your EAD, meaning not with an extension of your H4 status, are now entitled to an automatic extension of your EAD. That extension is valid for the till the earliest of three dates. The end of your H4 status as set by your current I-94, the approval or denial of your EAD application, or 180 days from your current EAD expiration date. So what that means is, let's say you're in H4 status until December 31st, 2022, but your EAD expires on January 1st, 2022. You file to renew that EAD. You would be entitled to an automatic extension of your EAD for 180 days beyond the current expiration date. So that means you have employment authorization until approximately June 2022. This is great news for people who have been filing for H4 EAD renewals. There are extensive backlogs in those processing. It's also great news for employers. It allows stability. A lot of individuals with H4 EADs are holding jobs here in the US, and whenever their status would expire, so like I said, let's say January 1st, 2022, if the individual did not have their new EAD, they had to stop working. That hurt the individual because they're no longer working and receiving a paycheck, and it also harmed companies because companies now had to put the employee on a temporary leave of absence or otherwise terminate them depending on how long they could afford to not have the person working. So this is a positive step forward. Now, it doesn't fix everything that's related to the delays. For example, this only really benefits those that have dramatic differences between the period when their H4 status expires and their EAD expiration date. If you're someone that has an expiration date that matches your H4 extension, your H4 status date, this automatic extension's not going to help you. If you're someone who has a slight difference, it'll allow you to capture a few days more beyond your EAD expiration date, but overall, it's not going to benefit you as much. If you're getting to a point where you are about to file for an extension of both your EAD and your H4 status, you may want to take an opportunity to talk to an experienced immigration attorney to come up with a strategy for how to best approach it. For example, if your H4 status was shortened because of your passport was expiring, or your spouse paid for premium processing and their H1B extension's already approved, in some cases, it may be best to just depart the country and come back in and get a new I-94 before you start extending your EAD. Again, when the time comes, please contact an experienced immigration attorney to get case-specific advice. Moving on to removal proceedings. Oh, I'm sorry, before I move there was one other good piece of information in the settlement. It applied to L2 spouses. Currently, if you are the spouse of if you're L2 visa holder, which is the spouse of someone who's in L1 status, you were eligible to work. The issue was you had to enter the US and then file for an employment authorization card. Before that time, you could not work. You had to wait till you actually received that physical plastic EAD in hand. Then you could work. Well, again, especially now with the backlogs, it's taking almost a year in some cases to get employment authorization cards. What USCIS in this settlement has recognized is by law, you should be allowed to work by your status. This means just like your spouse who has L1 status doesn't need an employment authorization card. They can begin working as soon as they enter the US by virtue of their status. It's the same for H-1B visa holders. What this new settlement indicates is USCIS is agreeing that L2 visa holders should be treated the same as their spouses, meaning from the moment you step foot in the country, you're authorized to work by virtue of your status. You no longer need an employment authorization card to start working. Now, there's a caveat to that. It's not going to impact everybody right away. Good news, bad news, I guess. So what's going to happen is you're going to have to have an annotation that indicates on your I-94 that indicates you're an L2 spouse. As long as you have that annotation, and that's going to come when you file for an extension, your new I-94 should have that annotation on it, or if you leave the country and re-enter, your new I-94 should have that annotation. Once you have that annotation on your passport, or on your I-94, you'll be able to use that with an employer for a List C document for I-9 purposes. So this means as long as you have that annotation, you have the other documents that are needed for an I-9, you will be able to begin work pretty much day one entering the US. Now, those of you who do not have that annotation, you will still need an EAD. That's the bad news. Now, if you timely file a request for an extension of your EAD, meaning you file before the current one expires, and that means USCIS receives it for processing, not you mailed it the day it expires, but as long as you file it before your current EAD expires, you will also get an automatic extension of your EAD, which means if your EAD expired on January 1st, 2022, you filed the application, let's say December 1st, 2021, you would be entitled to a 180-day extension by operational law. You don't need to do anything. Your receipt notice will indicate it. You can work till approximately June, unless, of course, your application is denied before then. But we're going to assume everything's going to go fine. You're going to get a new EAD. So, great news. It's not a perfect fix. There's still a lot of issues with these things, but it is good news. Now, removal proceedings. Couple new updates with removal proceedings. Some stuff we're letting you know as we're learning with courts reopening. The first is some cases, and I think this is primarily people who are represented. I haven't heard of it applying to unrepresented respondents, but those of you who are represented by an attorney, a lot of cases are in a case management system that is essentially hearings are being canceled. So you're not having like the first master calendar appearing. The court is canceling those and issuing what's called a scheduling order, where they're setting very specific requirements and deadlines for you to follow those. Most of the time, the first scheduling order is regarding pleadings. That's how you respond to the notice to appear. You indicate yes or no, I'm not a US citizen or national. Yes or no, I'm a citizen of this country. Yes or no, I entered on this date in this way. And that, let's say if you entered with a visa, I was authorized to stay until this day and I stayed beyond that. Those allegations will be spelled out in the NTA and you submit pleadings to that. So most of these the first one is for written pleadings. In those written pleadings, not only do you answer the allegations against you, but you also tell the court what kind of relief are you going to be seeking. Are you filing for a green card? Are you seeking asylum? Are you going to try to have your proceedings terminated? Whatever the case may be. Um, and you're filing with those with the court. In some instances, they're also asking for applications for relief. So if you are filing for asylum, a green card, cancellation of removal, you're going to have to send those applications in too. Most people are actually getting that as a second order, and the order is set, and you're supposed to submit your relief. Then you will get a hearing scheduled on your case with further deadlines for submitting any additional evidence. So that's an update on just general removal proceedings. There's also several people, and by several, almost 80,000 individuals who cross the U.S. border without inspection or iwi or illegally. I mean, there's different ways to say it. They are going to be put in a project. They're going to be placed in removal proceedings in what's called Operation Horizon. These are for people who receive notices to report after crossing the border versus a notice to appear. The notices of report instructed people to report to an ICE office in their final destination on a certain date and time. So now those individuals had not been placed in removal proceedings. They will be being placed in removal proceedings. So ICE is going to start sending out notices to appear. That's the document that puts you in front of the immigration court on these cases. They're going to send it with a general cover letter, also an interview notice that's to come into ICE, and materials regarding what you do if you've moved, you need legal assistance, etc. These packets will be provided to the individuals in English, Spanish, Haitian Creole, and Portuguese, depending on what is the best language indicated on other records that ICE, or information that ICE has during when they initially process the person. Now, when you are scheduled for an ICE appointment, you can take an attorney with you. You will have biometrics done. You will also answer some questions about where you're living and things of that nature. But unless you've been committed a serious crime or pose a danger to the U.S. or some kind of other risk, you likely will not be taken into custody. These appointments are not something to be afraid of. You should not avoid them. Avoiding them makes things worse, usually. Now, the important thing is if you came into the country and when you were first apprehended by CBP or spoke to someone from ICE and you gave them an address, but you're not living in that address, it's very important that you update your address with them, because that is the information you gave them is what they're going to use to mail you the notice to appear. The burden is on you to make sure they have your correct mailing address. If they don't have the correct mailing address and you never get the notice, you can be ordered removed in your own absence. In order to reopen such a removal order, you have to show that you didn't receive notice. Telling them I moved and didn't update my address is not going to be sufficient to reopen. So it's very important you make sure ICE has your current address. And if you are in removal proceedings or you're not yet and you receive one of these notices to appear, it's very important that you contact an experienced immigration attorney to determine what relief you could seek and how to proceed further. You don't want to delay. You want to make sure, what can I apply for? Let's get this ready. Get it in front of the judge as soon as possible. Because another thing that may be involved in these cases is very short times to do things in order to keep cases moving forward. Thank you for listening today. I hope you have a great rest of your day and a great weekend in the next few days. Thank you, and hope we'll see you next Thursday.